Welcome back to Law and Crime, everybody. Aaron Keller, along with Michel Bryant and attorney Julius Collins, will be joining us from Atlanta in a couple of seconds as we wait for courtroom activity to pick back up in the prosecution of Kellen Winslow II. We're looking live into that courtroom right now in California, where there have been some people coming and going from that defense table. We are waiting because jurors issued a note that they have come up with. They have decided 4 out of the 12 counts against Kellen Winslow II. Keep in mind, folks, that this is a case involving a series of 12 counts against this particular defendant. We are thinking internally, and again, this is just a guess, but we are thinking that the 4 counts that are final, the 4 verdicts that we're about to hear, may have to do with the accusations of Doe number 5. Why are we thinking that? Because she is the only Jane Doe, the only accuser, whose version of events resulted in a total of 4 counts. So that's the game plan that we're thinking might happen. And then, of course, the next question is, where do things go after that? Julius Collins joining us from Atlanta. I want to bring you into this discussion now if I can, because what do you think? Does this make sense to you that maybe that's where we're going with this?
Absolutely. I mean, that's the only Jane Doe that has 4 counts. You got count 9 through 12, 2 counts of lewd conduct with cruelty to an elder, battery against an elder. But the jurors coming back and saying they only reached a decision on 4 of the counts, it definitely points to that.
Yeah, that's what I'm thinking as well here. Of course, they're not the most serious accusations. The most serious accusation is the very first count. That's the kidnapping, and that's the one with the life sentence. So these are all misdemeanors. These are lesser counts. And then I want to know, okay, what happens to the other counts here? Is the jury hung? Does the jury just need more time? Because the note was a little bit cryptic as to exactly what the jury wanted to do. So is this a status update, or is this a sign that we are hung and we don't know what else to do?
No, I don't think it's a sign as of yet. One thing that judges do here in Atlanta, Georgia, they'll actually ask, hey, of the jurors, are you hopelessly deadlocked? At that point, they may or may not give the jurors more time to go back and deliberate. But just based on the notes that the jurors given, I don't think this is any sign that they're hopelessly deadlocked at this point until the judge asked them and they said, Your Honor, we're at an impasse. We can't reach a decision as to the remaining 8 charges.
This jury's been at it for a long time. They've been going for more than 20 hours. I think they're at the 22, 23-hour mark. Of course, at this point, they may just be back there waiting for things to pick up for the judge to bring them out. We were told that that was going to happen at 3 o'clock Pacific time, their local time in California. We're at 6 o'clock here on the East Coast, waiting to see whether or not whether this is going to roll along in a timely fashion. Meantime, let's listen now to some previous discussions here. This is from the prosecution closing arguments.
Lightning certainly doesn't strike twice, let alone 5 times. This man took what he wanted from them and threw them aside like a piece of trash, because that's what he thought that they were. Make no mistake, he has proven himself to be a sexual predator. Time and time again, motivated by his own perverse sexual pleasure to dominate and take what is not his. Ladies and gentlemen, that is his motivation. To steal their dignity, who they are, regardless of what effect that may have on them. That's what happened here. And you've heard it from the witness stand time and time again. And you've felt it in their words.
And there you heard the prosecutor pushing that tactic of trying to lump a lot of the accusations into a conviction. Lightning doesn't strike twice, let alone 5 times. The volume of the accusers' indication that these women are telling the truth. That's what the prosecution wanted the jury to believe. Of course, the defense said that's not the way court works. That's not the law. We'll talk about that argument a little bit later on tonight. But first, a little bit more from the prosecution's closing argument. Okay, we are waiting for the judge to bring the jurors out there in the trial of this former NFL player, Kellen Winslow II, accused of a series of crimes, most of them sex crimes. Here's what we understand is going to happen. They're going to bring the jury in. The judge will accept these verdicts on 4 out of 12 counts, and then ask the jurors if they are unable to reach verdicts on the remaining counts. If the jury says yes, then he will declare a mistrial on those additional charges. Attorney Julius Collins here in Atlanta, Georgia, watching this along with us. So California has an Allen charge, a dynamite charge. Apparently the judge does not want to use it in this case, and that may be because the jury's already been at it for 22 hours of deliberations.
Absolutely. It's been 5 days. I'm sure everyone is ready to get this case over and done with. But I'm surprised that the judge didn't read the Allen charge, which basically says, hey, if you all need some more time, try to reach a verdict. Whether it's guilty or not guilty, you can't force anybody to try to reach a verdict as far as guilty or not guilty. But I'm surprised the judge didn't read it. But like you said, Aaron, 5 days. The judges, they may be stuck.
Yeah, exactly. Look, I agree with you here. This judge has been very, very efficient. He has been by the book. He's been clear with rulings. He's checking the law when he has to make an evidence decision. I think that maybe this judge's approach, well, look, it must be dictated by some experience and some sense of efficiency, because he's saying, look, okay, he's going to ask him. He's going to feel it out. He's going to see what the deal is, Michel Bryant, and then he's going to read the faces of the jury here and see what happens. But we're going to go back in right now because the jury's back. Okay, so this is an interesting mixed verdict here. We were completely wrong on this. This was not a unanimous verdict as to all 4 counts as to Jane Doe number 5. This was a complete mix. Looking back at the list, Jane Doe number 2, guilty, count 4. Jane Doe number 3, guilty, count 6. Jane Doe number 5, guilty, count 9. Jane Doe number 5, a second time, not guilty, count 10. Michel Bryant, you're sitting here listening to this with me as the jurors are polled. This is some scalpel laser precision verdict reaching here by this jury.
This is actually pretty impressive. What we know for a fact is that 1 and 4 were not believed at all. They're done. There was nothing that, or at least they couldn't convince a unanimous jury of anything. We're assuming they're hung on all of those counts. So that I think is interesting, because the reaction
and Jane Doe
from
number
folks,
4 potentially here too.
Exactly.
So these are basically the Jane Does that were the homeless and the transient, 1 and 2. And number 4 was the one who said she was attacked when she was 17 back in 2003.
Right, consensual and then non-consensual.
No verdict on those whatsoever.
Correct. So they couldn't come to a guilty decision on those. That's all we know for a fact. Who knows where they were split. So that I find interesting, because I think the perception of 1 was horrible. Jane Doe 1 did not come across very well, and this jury apparently could not find guilt with what she had to say. And Jane Doe number 4, the biggest concern was the lapse of time, and the fact there was consensual then non-consensual.
Yeah, let's go back in and listen to what's happening now. Wow, this is interesting, and interesting on top of interesting here. So they're going to stick with this, Michael. I know you were just talking about, well, maybe they weren't unanimous on this. Maybe they're just going to keep going here. These were the easy counts for them.
Isn't that amazing? I think it is really interesting that they would have come to those decisions on this hodgepodge of charges, and now they're going to go back and give another whack to what they've been working on.
Yeah, I mean, so they asked for a little bit more information as to Jane Doe number 3, that jury question, well, you can't get the map. Apparently, they didn't need the map. They turned around and convicted on that. Julius here, they asked for the whole readback. We spent all this time last week listening yet again to the testimony of Jane Doe number 4 and her friend. They didn't reach any verdict on that, and they spent nearly an entire day listening to it a second time.
Absolutely. Again, Aaron and Mike, this was a case about credibility, whether or not the victims were credible. Jane Doe number 1, no decision made on that. Is guilty or not guilty. We don't know the numbers at this point, but it goes to show that the jurors are having issues with credibility, because we got to remember there's no physical evidence. There are no witnesses to these crimes. Jane Doe number 4, same thing. No idea of where the jury is heading with this. And again, no physical evidence. It's just solely testimony. And Mark Carlos did a great job on cross-examination. I think he did a great job throughout this entire trial, just questioning and attacking the credibility of every alleged victim.
Exactly. We're going to go back to court now for some more live discussion outside the presence of the jury. Yeah, I think the judge's opinion summed up the opinion of many of us who are watching this case as it rolls along. Julius Collins is with me from Atlanta, Georgia. Michel Bryant here in New York. Putting in a little bit extra time on this, Michael. So I kind of agreed with the way the judge summarized his thoughts of this whole situation here. They say they want more time. They surprised me too.
I just think it's odd the way it's rolled out, that the jury, on their own said, hey, we've got 4 we've figured out. We want to share that with you. And no indication we need more time on the others. We don't need more time. Then they came out, and it was clear that the judge didn't learn until that moment that they weren't done. He thought they were done.
Yeah, Julius, I mean, what I'm seeing with this here is perhaps people like you and Michael and I are just so used to the process here that if we sat on a jury, we would send very specific notes out. We would say, we have reached a verdict on these counts, but we need more time. We are not deadlocked. Do not freak out. We are just letting you know that we are working diligently. And then the judge would say, oh, okay, now I know what's going on. They're still alive back there. They're drawing breath. Okay. Maybe this jury just isn't as used to the process as we are, but they are at least conscientious enough to turn around and say, we had better let them know what's going on because we've been back here a long time and we don't want them to get worried about us.
Absolutely. And like you said, hey, me, you, and Michael, we normally would send out very detailed letters or notes to the judge like, hey, we're hopelessly deadlocked. Sometimes we even have jurors who send out like a 9-3, 8-4 number on whether or not they're, whichever way the charge is going to go. But this year, they've been sealed tight on this situation.
Exactly. Look, okay, so, one thing that I'm looking at here is we were trying to speculate as to what this might be. We said maybe these are all going to be counts as to Jane Doe number 5. But what we've got here, the more I flip through this, and of course, folks, I keep my paperwork from the court handy in front of me here. As to Jane Doe number 5, the 77-year-old woman who made the accusations about conduct in a gym, they reached a guilty as to the first lewd conduct. That's what was going on in the exercise equipment, as I understand it. And they reached a not guilty as to lewd conduct, presumably what's going on in the jacuzzi. And that makes logical sense because what happened in the jacuzzi was subject to a much more punctuating attack that maybe she didn't see what was up because of the bubbles in the pool. And maybe when he was making some sound of pleasure, he was reacting to the jacuzzi, not doing something else, but that she had a clearer view of what was going on in the exercise equipment. So I'm taking that away from it, Julius. Does that make sense to you logically?
Absolutely. One thing I do whenever I watch and study these trials, I listen closely to the different victims or witnesses' testimony. And one thing that she said that was surprising, it was different from the actual police report that she made. In the police, she stated that she physically and she could actually see him, excuse my language, but masturbating or pleasuring himself. But then it was so many bubbles that I couldn't really tell what he was doing underneath the waters in the jacuzzi, and that I believe he was doing it. So I think that contradicting alone, that's the reason why Mr. Winslow got the not guilty on the on count 10.
Yeah, Julius, I think that I agree with you, and there was a little bit of movement in the courtroom camera. I was just checking to make sure something else didn't happen here. We're going to take a break, though, here on Law and Crime real quick. Michael, I don't know if you want to stick around with us. Or if
whatever you need. I'm here for you.
I don't want to, hold you here against your will. I don't want to be charged with kidnapping
Let's
or
just see what happens.
False imprisonment. Okay, we're going to see what happens. I just didn't want you to just disappear here. We'll take a break here on Law and Crime and come back with some more analysis on this mixed verdict from the jury. That's in just a moment.